movies. And we're here with Attorney Dao, who is one of Seattle's preeminent foreclosure attorneys, even though she'll never tell you that, but she is. And
I don't know about famous, just because I do this every day.
Preeminent. Well, we all live in infamy, those of us who challenge the banks, we know that, so.
Yeah.
That. Well, let's get right to it. Recently there was a segment on King5, and the segment dealt with companies like Safeguard and other the various, I'll call them, for lack of a better term, bank executioner thug types who violate the law and dispossess people of their homes before there's a final foreclosure order and possession order.
Okay. So and I want to point you to the fact that the notes of 6124, the Deed of Trust Act, does refer back to 7.28.230. And it says, when there's a question regarding possession of real property by trustee of deed of trust to collect rents and profits, you go back to the statute. So that makes me believe, or that confirms for me, that possession of a property before foreclosure is prohibited. Absolutely. There's just no and or buts about it.
Thank you, Counsel.
The statute says the deed of trust also gives them the right to rent, right? And 7.28.230 says you can get rent, but you can't take possession. You know, you can't come into my homestead, even if I abandon it, even if I walked away for months and I don't live there, you can't come in. And I think the statutory language is rather absolute. I don't think that you can argue with that at all. And would say, well, before you can do a deed in lieu, you have to do short sale. Okay, I'm trying to do short sale, but my God, you changed the law a couple of times.
Right.
And now the realtors on both sides are saying, can't work with you. Your bank keeps doing this. You know, and then on one hand you're negotiating with me, and on the other hand you're trying to evict me, and we call it constructive eviction basically. The statute is actually under quiet title and ejectment, and it's RCW 7.28.230 sub 1.
Sub 1, yes.
And it says, you know, no, just because you have a deed of trust or mortgage, it doesn't give you the right to take possession.
Yeah, let's read the exact statute so the people out here can have it. I have it right here.
Yeah,
It states, a mortgage of any interest in real property shall not be deemed a conveyance so as to enable the owner of the mortgage to recover possession of the real property without a foreclosure and sale according to law. But in reality, Counselor, that's not really what happens out here, is it?
Right, right. And what they're saying is that because you signed the deed of trust, we can do whatever, right?
Right.
And we have a defense counsel who tells us, and when we showed them this law, we said, what about this language? It seems pretty black and white, you know, especially if you haven't conducted a full-blown foreclosure sale and you have no court order allowing you to enter. What are you doing? You know, well, the question that Chris Ingalls had is, has anybody used this statute and prevailed?
Right.
Many people don't know about the statute, apparently.
That's probably true too.
So you can't use it and be successful if you don't know the existence of it, right?
Right.
So the purpose of the, you know, whatever you're trying to do, the segment is really to educate the public about the existence of the statute. How does it apply? You know, how does it apply in the scenario of these banks hiring thugs to go around and you know, break into people's homes and changing locks and so on and so forth. Now, just like Bain, you know, you can't really get the issue settled until you bring it to the judge's attention, have a decision on it, and then move forward. If you have to appeal, much like Bain and Frias and Lyons, it's, you know, it's how law are interpreted or made.
Indeed.
So let's talk about the background. You know, when you sign your loan documents, the deed of trust and the note, the deed of trust has a provision, and it's generically appearing in every deed of trust, really. It's either paragraph 5 or paragraph 9, and it says that if you are in default on any terms, either payments or, you know, failure to keep the property safe and secure and protecting, you know, their collateral,
yes,
then they have the right to come in and take reasonable measures to protect their collateral. You sign up on it, whether you're aware or not. That provision is there.
Sure.
So these banks then under the guise of preservation, they would hire contractors. The two big companies they hire, as we can see, is Safeguard Properties and LPS, and they're now known as Black Knight. So LPS Field Services, aka Black Knight, and Safeguard Properties would then in turn hire subcontractors, people who live right here in Washington,
Of unknown origin.
no certification. To go around and conduct what they call home inspections, and then home inspections will eventually escalate to home preservation, would translate into them changing the lock on you in the name of default.
Right, during which time we know, and I know from first-hand experience, that homeowners are finding things missing from their home, copper plumbing is stolen, appliances are stolen, things are abused and ransacked, the whole 9 yards leading up to the final dispossession.
Sure. The media has covered the issue extensively, and what we've learned from all these reports is that the guys on the ground, the home inspectors and the preservation people, get paid very little money. I mean, in one of the cases we have, the testimony came out that the home inspector only gets paid $3 per inspection. The person who does these home inspections tells us that he conducts, on the average, 600 inspections a month. And then these guys, being untrained and possibly unlicensed, who knows?
And possibly unethical.
True,
Well, let's keep in mind, I've spoken with the Illinois Attorney General Lisa Madigan, who filed a lawsuit against a Safeguard, and I know I have a Busby case that I've been reporting on for some time. Linda Urkel, I believe her name is the corporate attorney for Safeguard. They're based in my hometown of Cleveland. And she completely lied in a case out there that I won't get into right now. But so they do that, and they're tied in with the Bush family. They all, the attorney Urkel, or Keela, I think her name is. She is appearing at the 5 Points conference out there in Texas. And immediately thereafter, she was contacted by the quasi-criminals at Safeguard Properties, who basically break into houses, steal and vandalize, and run amok, often prior to judgment. Now, HuffPost ran a story on them, and you can see their principals there, Alan Jaffa, Robert Klein, and Linda Erica, who I see graduated from Cleveland's Lesser Law School, so I guess she feels obligated to do sleazy things. Now, I graduated from Case Western Law School, and I frown on her tactics. And I hope that the homeowner in this instance sues them immediately for a restraining order. Get out of her house, stay off of her property. If I hear tell of you thugs entering the property, I will find Miss competent counsel back in Ohio, and I'll be at your office with cameras blazing.
Cases that we have dating back in the 60s and the 30s, it's very clear what the court said. It is a public policy in the state of Washington that you cannot repossess my home. You can't do that, even if I abandon it.
Right, you can't do it until you can.
Right. You can't do it because the legislature gave you a lot of room, wiggle rooms for the banks by way of non-judicial foreclosure, cheap and fast. You can do that, or you can do judicial foreclosure. You've got many means at your disposal, and for that reason, you just can't come in and attempt to take my house.
Yes, you need an order of possession.
Right.
Writ of possession must issue before you can get in my house.
Yeah. Communicate with the servicer and tell them, I still live here. I live here with my children. I do not want to be, disturbed.
Yeah, well, they're going to argue that's a unilateral breach, and I'm going to say that no, it doesn't apply that way because it was an adhesion clause in the first place, and it's still subject to law in this state.
Yeah, and that's the concept of you can't contract around the law. And if that provision is illegal, the remainder of the contract can be enforced, but that particular provision got to get out.